Section 10, Legal Hotline Q&A, Part 2. Introduction. Agency mistakes usually start with good intentions. In the previous section, we discussed the importance of agency disclosure, the rule of three, implied agency, and making sure clients understand exactly who we represent. Now we continue our legal hotline discussion by looking at several real-world situations that frequently create confusion for Arizona licensees. Most agency violations do not happen because an agent intends to do something wrong. They happen because an agent assumes, forgets, shortcuts a process, or fails to document something properly. This section focuses on common agency issues involving disclosure, offers, dual representation, shopping offers, and limited service listings. Licensees must disclose their license status. One of the most commonly misunderstood agency issues involves a licensee selling their own property. The legal hotline scenario involves Jane, a licensed real estate agent, who lists her own home with another brokerage. The question becomes whether the listing brokerage must place owner-agent on the yard sign. The answer is no. The rule requiring an owner-agent disclosure applies to the licensee who owns the property, not to another brokerage that is marketing the property. However, Jane must disclose her status as a licensed real estate agent at or before the time a purchase contract is entered into. Rules updated. Disclosure builds trust. The updated Arizona rules continue to emphasize transparency and honesty in real estate transactions. When a licensee has an ownership interest in property, disclosure is not simply a legal requirement, it is a trust issue. Buyers deserve to know when they are negotiating with someone who holds a real estate license, because that person is presumed to have specialized knowledge about the transaction. Real-world example: the silent agent seller. A buyer submits an offer on a home. During escrow, the buyer discovers the seller is actually a licensed real estate agent. The buyer immediately asks, "Why wasn't I told that?" Even if nothing improper occurred, the buyer may now question the entire transaction. Proper disclosure eliminates that concern before it becomes a problem. Presenting offers. The seller makes the decision. One of the most important duties of a listing agent is presenting offers. The legal hotline asks what happens when a seller tells the listing agent, "Don't bother me with offers under $180,000. Later, an offer arrives for $172,500. Should the listing agent present it? Yes. Unless the seller has provided written instructions stating otherwise, the listing agent should present all offers to the seller. Notice the key word, written. A casual conversation is not enough. Real-world example: the offer that almost wasn't presented. A listing agent receives an offer significantly below the asking price. The agent thinks, the seller would never accept this. Instead of presenting it, the agent ignores it. A week later, the seller learns about the offer and says, "I would have countered that offer." Now the agent has a problem. The agent's job is to present offers, not decide which offers deserve consideration. Dual agency can appear later in the transaction agency. Relationships can evolve. The legal hotline discusses a situation where a listing broker represents the seller in a transaction. Before closing occurs, the buyer asks the listing broker to list the buyer's current home for sale. Can the broker do that? Yes. However, the broker now represents both parties in related transactions and should obtain the appropriate dual representation documentation, including the consent to limited dual representation agreement. This is an excellent reminder that agency is not static. A transaction that begins with single representation may later involve limited dual representation if circumstances change. Real-world example: the buyer who becomes a seller. A buyer closes on a new home in 60 days. The buyer says, "Since you're already helping us, can you list our current home too?" That sounds simple. However, before saying yes, the broker should evaluate whether additional agency disclosures or dual representation forms are needed. Agency relationships must be reviewed whenever the facts change. Shopping offers. Protecting the seller's interests. One of the most debated agency issues involves shopping offers. Imagine the following. Buyer number 1 offers $100,000. Buyer number 2 offers $105,000. The listing broker contacts buyer number 1 and asks if they want to improve their offer. Buyer number 1 asks, "Can I see the competing offer?" May the listing broker provide it? According to the legal hotline guidance, yes, unless the seller has instructed otherwise or confidentiality has been specifically agreed upon. The listing broker's fiduciary duty is to obtain the best possible terms for the seller. Therefore, shopping offers may be appropriate in certain situations. Agency reminder: your loyalty matters. This situation demonstrates the importance of fiduciary duties. The listing broker works for the seller. The listing broker's responsibility is not to help one buyer beat another buyer fairly or unfairly. The responsibility is to help the seller obtain the best possible price and terms. That fiduciary obligation often drives decisions regarding multiple offers. Real-world example: multiple offer madness. A home receives 8 offers. The seller instructs the listing agent, "Go back to everyone and ask for their highest and best." The listing agent follows the seller's instructions and creates a competitive bidding situation. The listing agent is not representing the buyers. The listing agent is fulfilling duties owed to the seller. That distinction is important. Limited service and flat fee listings. The modern marketplace has introduced more limited service and flat fee brokerage models. In these situations, the listing broker may place the property into the MLS, but have little involvement in negotiations or contract presentation. The legal hotline explains that even if the broker provides limited services, the broker remains subject to Arizona statutes and ADRE oversight. The listing broker should still be identified in the purchase contract and maintain transaction records. Rules updated. Records still matter. A broker cannot avoid regulatory responsibilities simply by offering fewer services. Arizona law continues to require brokers to maintain records and comply with real estate statutes and rules. This means limited service does not mean limited accountability. Flat fee does not mean exempt from supervision. MLS-only listings do not eliminate broker responsibilities. Documentation remains critical. Real-world example: the missing broker. A buyer's agent presents an offer directly to a seller because the listing broker instructed agents to negotiate directly with the owner. The buyer's agent should pause and ask, "Do we have a written waiver? Has the seller authorized direct negotiation? Have agency relationships been clearly disclosed?" Under Arizona rules, negotiations generally occur through the principal's broker unless proper written authorization exists. Good documentation prevents misunderstandings later. The big lesson: the legal hotline examples in this section reinforce several agency principles. Disclose license status when required. Present offers unless directed otherwise in writing. Review agency relationships when circumstances change. Understand fiduciary duties when handling multiple offers. Follow proper procedures when dealing with limited service listings. Document everything. The strongest protection for both clients and licensees is clear communication supported by proper documentation. As we move into the next section, we will continue examining agency responsibilities and the situations where disclosure, loyalty, and professional conduct intersect in everyday real estate practice. Online discussion questions. Question 1. Why should all offers generally be presented to the seller? Answer: the seller has the right to decide which offers to accept, reject, or counter. Unless the seller provides written instructions otherwise, the listing agent should present all offers. Question 2. Why must a licensee disclose their status when selling their own property? Answer: buyers know when they are negotiating with a licensed real estate professional because that person may have specialized knowledge and experience related to the transaction. Question 3. Why is documentation especially important in limited service listings? Answer: even though services may be limited, the broker remains subject to Arizona statutes, rules, supervision requirements, and record retention obligations.